Good morning, friends. The Honorable Supreme Court of India issued stay orders on the inquiry report against the Madhya Pradesh District Judge and also gave notice to the Madhya Pradesh High Court over the charges of sexual harassment of a district judge against a woman judicial officer. Fine, okay, these things are quite common, but the observations are the OBITER DICTA. OBITER DICTA observations, oral observations by the court during the inquiry of this quash petition under 482 CRPC. Right, so the Honorable Supreme Court, he stated, this is a regular phenomena in our system now. Complaining against a judge by a judicial officer has become a common phenomena in our system now. It has become the trend and it has become the practice now. He has commented, he himself is commented. So this is what we have to observe. So OBITER DICTA, you may be knowing, OBITER DICTA is, of course, it is only oral remark. It has no connection with the case. Of course, basing on the OBITER DICTA, you cannot say that the judge will acquit the case, but it is opinion. Right, now he stated the position. Though this is done by 3 judges bench, including the CJI, Shri Sharad Arvind Bobde, A.S. Bopanna and V. Ramasubramanyam. Right, on behalf of the district judge. So basically, the facts of the case are like this. There is a district judge in Madhya Pradesh. He has worked for 32 years and he is going to retire by the next year. That means this year. Right, during the year 2018, a woman judicial officer complained to the Gender Sensitization and Internal Complaint Committee, that is GSICC, Gender Sensitization and Internal Complaints Committee, that this district judge harassed her, sexually harassed her. So basing on this, normally the internal complaint committee, they have to conduct an inquiry. Right, now we have to use the provision, we have to see the provisions of the sexual harassment of women at workplaces within brackets Prevention, Prohibition and Redressal Act 2013. So according to this act, according to section 9, a woman can make a complaint in writing to the GSICC or Internal Complaints Committee. Any aggrieved woman, she can make a complaint to the Internal Complaint Committee. Right? So according to section 10, when once the complaint is received, normally it is the duty of the committee to hold conciliation. Before starting the inquiry, to hold conciliation, a conciliator will be appointed, he will call both the parties and he will try to settle the issue. Here what they say is the conciliation has taken place between the judicial office and district judge also, but it was overlooked because 3 inquiries have been conducted in this regard. Alright, so then according to section 11, the inquiry, so the inquiry has to be conducted, so they have to proceed with the inquiry. So at the time, normally the powers of the civil court, that is summoning or taking evidence of on oath, then discovery, documents, commissioner, questioning of documents, all this, just like a civil procedure code, they will observe. And if they find there is a prima facie case, normally they will refer the matter to the police, normally under section 509 of the IPC or 354 IPC, like that. Right, then section 13 is also, after the completion of inquiry, what they have to do, they have to give the report to the concerned head, either asking for compensation, asking for a transfer of the officer, asking for a report to the higher ups, like that they will conduct the report. Right, so please remember, there are attached rules also. Rule 7 is important. Rule 7 also says about the manner of inquiry, how the inquiry will be conducted. Same, of course, when section 11 is there, that procedure will follow, but normally Rule 7 says 6 copies have to be prepared and one of them have to be given to the complainant. So this is the formula. Of course, here the main point is the advocate on behalf of the district judge. He says that even though the conciliation was done, the Madhya Pradesh High Court ordered another inquiry by same equal cadre officer. That means by another district judge who has recorded the statements of three persons who has not at all called the victim, and who has not recorded his given statement, and who has not followed the principles of natural justice. Ultimately, basing on the evidence of the three witnesses whom he examined, he came to the conclusion that this judge has resorted to sexual harassment of that woman. Therefore, he was transferred from that place, and now these proceedings are issued against him. Then this district judge has approached the Madhya Pradesh High Court, but they have not given any relief. Ultimately, he came to the Supreme Court. So these are the facts of the case. So basically, to be precise, I want to put it to you that this judicial officer has sexually harassed another judicial officer. But please remember here, the inquiry report says the text, WhatsApp text messages that were transpired between this district judge and also that woman. Of course, the advocate says that the WhatsApp messages, of course, they do not carry any weight. You cannot build the case, or you cannot probe the matter only basing on the WhatsApp like that. Anyway, of course, they will say like that. But the comment of the CJI, this bears most important. So this is the regular phenomena in our system now. When something at the verge of happening, all kinds of these things are. That means when one person is about to elevate it to the cadre, higher cadre, all these things will start happening. What to do? This has become the trend now, and it has become a practice now. So he has commented like this, right? Okay, whatever it is. Since the woman judicial officer filed a complaint of sexual harassment against the district judge, definitely they have to conduct the inquiry, they have to come to the conclusion, and then only. So anyway, the Honorable Court, Supreme Court of India, it has stayed the proceedings of the High Court. That means the orders given against the district judge, they were stayed for some time. Of course, notice was given to the Madhya Pradesh High Court. The final orders will be decided to. Right. So here the main point is the procedure had to be adopted, I told you. But here what happened is 3 inquiries were done. So this is based on the discrete inquiry. Discrete means without the knowledge of the person. Normally what you do when you are conducting an inquiry. What is an inquiry? Inquiry is an inquiry conducted by the court other than the police. So they have to follow the principles of natural justice. Of course, there are certain occasions where the so-called discrete inquiry was also conducted. Here, they have done the discrete inquiry, that too by an equal officer cadre, by another district judge. So, basing on the WhatsApp messages between the petitioner and with the woman officer, he has come to the conclusion that sexual harassment took place. So, actually, in April 2009, this, of course, we have to remember the incident of the Supreme Court. In April 2019, a junior court assistant of the Supreme Court had made wild allegations. He had sent affidavits to 22 judges of the Supreme Court, alleging that CJI, the then CJI, Ranjan Gogoi, he had made sexual advances to her in his residence office on 10th and 11th of October 2018. Of course, immediately Ranjan Gogoi came to the hall and he said that it is a matter of great public importance and it is touching the independence of the judiciary, and this was a bigger plot to deactivate of the CJI by the politically interested persons, like that he has stated. And in that connection also, that woman was subjected to inquiry, right? Of course, here what happened is, she was not given the benefit of taking the assistance of an advocate, because she said, you people, you are great people, you are judges, what you are speaking, I am not able to understand. If there is a judge, if there is a lawyer, then I can be able to reply to your questions, for which they said there is no such procedure. And secondly, she asked for the copy of the videograph, which they did not give. Ultimately, the case has gone to winds and it is said that the allegation is not substantiated. Of course, you may be knowing in that case what happened. The husband and her brother-in-law of who were working in the police force in Delhi. They were suspended, and a lot of harassment was done to him. She was subjected, she was also arrested in the case of the Prevention of Corruption Act. Of course, the victim, the complainant was not raised. He did not come to the court. All these things happened ultimately when Gogoi sir has gone and when this CJI has come. Now she was reinstated. What all this does mean to say? Do you mean to say that nothing happened? It is still suspicious, right? Anyway, the comment by the CJI, normally it gives us so much of importance, and definitely, since we cannot comment on the activities of the court, but definitely this order is it will be subjected to so much of adverse criticism by the lawyers, by the legal community, because already we have seen the incident of the Supreme Court. So why a woman officer comes to the Internal Complaints Committee and allege against a senior man? So he doesn't she have the morality? Why don't we think in that way? Okay, whenever a woman gives, okay, you inquire the matter, testify whether it's correct or not. So somebody says it's correct, somebody says it is not. And in Hindu I have seen. So the inquiry disclosed that no further action may be taken, but still the High Court volte-face suspended him, like that they have written. So different inquiries have been. Who has ordered for the inquiry? The Judicial Department, the MP, High Court or the district judges, they have done the inquiry. So they should have based on one inquiry report. So then how can it be commented that the women are always in the habit of leveling allegations against the district judges, that too at the time of promotion? I think this comment may not hold good. And what I suggest is that an inquiry should be conducted. If the inquiry is proved, yes, he has to be sent to gallows. If it is not proved, further action has to be followed, action to be dropped, and she has to be taken to task. That's all. You cannot say that the time has come now, they are leveling allegations. Yes, so many things are happening. The SC/ST Act has been introduced. 90% of people say it is being misused. Do you mean to say that it is misused? No. Similarly, 498 harassment cases. Yes, everybody tries to comment that in these days the women are using the 498 as a weapon against the gullible husbands. Do you mean to say it is correct? Certainly, we cannot generalize it. So, still, why this act has come, why J.S. Verma recommendations, why Nirbhaya incident, why Disha Act has come? Because still there are incidents where the male-dominated society, still they are harassing women. Still the male people, they are seeing the woman as a toy, as a beautiful doll, not as an equal cadre. So that is a major problem. Anyway, so these are the comment by CJI. As an elder, normally I may not be agreeable. Anyway, let us see what will happen. So this is OBITER dicta. Since it is OBITER dicta, we cannot say anything, because OBITER dicta is a statement, a generalized statement during the course of inquiry, and please remember, it does not have any effect on the judgment. Right? Okay. This is the case law. Please read it and enrich your legal knowledge. Thank you.